Good morning, good afternoon, and good evening. My name is Kevin Tan, and on behalf of the Center for Asian Legal Studies at the National University of Singapore, a warm welcome to all of you and to our guests for this version of the virtual roundtables on Asian law. Before we begin, let me just say a little bit about the Center for Advanced Asian Legal Studies at the Faculty of Law at NUS. We're a research center established as a platform for the study of Asian legal systems and Asian law. And we're very happy to be able to present this version of the virtual roundtables in Asian law, which, believe it or not, was started almost 4 years ago. In fact, this month we would actually celebrate the 4th anniversary of our viral talks. And with that, let me begin with today's presentation. Bangladesh is one of the most populous countries in the world. In fact, it is the 8th most populous country in the world and the 5th most populous in Asia itself. Yet, from a constitutional comparative point of view, its constitution has not been studied in as extensive and intensive a manner as perhaps some of the other Asian countries. Obviously, one thinks of China and India as obvious countries for study, but Japan's constitution, for example, has been studied far more than that of Bangladesh. And to address this particular gap, we now have a wonderful new book by my dear friend Ridwanul and Rokeya Chowdhury that commemorates the 50th anniversary of the Constitution of Bangladesh, title of which is A History of the Constitution of Bangladesh, the Founding, Development, and Way Ahead. With us this morning are distinguished speakers, in particular, guests of honor. I'd like to welcome with us Mr. Justice Dr. Syed Refaat Ahmed, whom I had the great pleasure of meeting in Dhaka quite some years ago, more than a decade ago, as we were recalling just now. And of course, the editors of this wonderful volume, Ridwanul Hoque, who is currently at the Kent Institute in Australia in Melbourne, and Dr. Rokeya Chowdhury, a lawyer specializing in immigration law. And bearing up the task of commenting on this book is Dr. Cynthia Farid, who is currently a global academic fellow at the University of Hong Kong, although she's coming in to us from Dhaka today. So with these brief introductions, may I invite our guest of honor, Justice Refaat Ahmed, to address us. Justice Ahmed, please.
Thank you, Kevin. Ladies and gentlemen, it is a truism that a state should try so far as possible to govern through a coherent set of principles whose benefit it extends to all citizens. The judiciary's role as an organ of the state is to declare the true and legal content of such principles. That, in my opinion, is the essence of rule of law and hence constitutionalism. This virtual roundtable on Asian law, organized under the aegis of the Center for Asian Legal Studies, Faculty of Law, National University of Singapore, provides a platform for this new publication on the history of the Constitution to bring forth ideas and recommendations at a significant juncture for the nation. The publication is a critical analysis of the current state of constitutionalism in Bangladesh, as probed into by 14 chapters in the book, which is an honest and bold effort to take the Constitution to the world. The objective is to provide a prognosis of constitutionalism in the years and decades ahead through a holistic consideration of the present state of the Constitution, a document which stands out for its resilience over the past half a century or so. There is a common thread binding the chapters or essays in this book, and that is the belief that the Constitution is a living document permitting of perpetual reinvention. In this, much reliance is placed on the competence, authority, and power of an independent judiciary to undertake the progressive interpretation of the Constitution. Indeed, this is key to the survival of the Constitution itself. This is where my modest contribution to the book becomes relevant. Purely jurisprudential and autobiographical in nature, my chapter on the rule of law sifts through judgments from the perspectives of positivism and realism. And the takeaway for the reader from it will, I hope, be that the enthronement of the law, to borrow a phrase from Sir Thomas Bingham, former Lord Chief Justice of England and Wales, clearly places the independent judicial function of interpreting and applying the law at the forefront of the separation of powers under the architecture of the Bangladeshi Constitution. That, in turn, is the essence of the notion of rule of law, as is readily discernible in the Bangladeshi context in the Constitutional Supremacy Clause, that is Article 7, which declares the Constitution as the solemn expression of the will of the people. As a realist, I believe that it would be a folly to treat such popular will to be static and immutable. Accordingly, the spirit of the Constitution, over and beyond merely the letter of the Constitution, must stay abreast of such popular will. Failure to do so places constitutionalism itself at risk. In my opinion, the primacy given to popular will lies latent in the very genesis of the Constitution as a social contract, aiming for the establishment of a democratic society free from exploitation through limited government. In the annals of the liberal tradition of political thought, this best corresponds to John Locke's narrative of the relation between the sovereign state and the sovereign people, in the context of the people being recognized as the legitimate source of the state's powers. In that sense, a constitution as a compact is basically a license to a limited government upon express conditions attached, marking, in Locke's vision, the essential transitory device from a state of nature to that of regulated governance. Such transition to limited government becomes necessary on account of inadequate regulation of guarantees to life, liberty, and property, and the resultant conflicts arising in the state of nature. The device adopted to oversee this transition is a social compact, to organize into an independent society that gives up certain facets of its autonomy to a civil association to govern in a manner that ideally best serves the governed. The citizenry, organized in a civil political society, retains the power as final arbiter of the quality of governance and of resultantly ushering change in the instrument and mode of governance. John Locke presciently opined that to return for legislative and executive rights so relinquished by the citizenry, the social compact significantly made the citizenry the repository of sovereign power, or capacity to determine the beneficial use of such rights. Such consent given actively and directly to establish a governmental structure led to such consent being deemed to be expressed through the people's representatives to govern as trustees as per the social compact. Constitutionalism, broken down into its core components of democratic governance, human rights, and rule of law, presupposes too the existence of an independent judiciary. The concept of judicial independence is a complex one, and the quest for attaining and maintaining such independence is equally daunting. I would therefore be remiss if I, as a stakeholder in the judiciary, did not reflect here on the issue as has a bearing on the judiciary in the ultimate analysis remaining a functional and relevant, if not an indispensable organ of the state. The starting point here must, as the UN Basic Principles on the Independence of the Judiciary declare, be the ability and authority of the judiciary to decide matters impartially, without any restrictions, improper influences, inducements, pressures, threats, or interferences, direct or indirect, from any quarter or for any reason. The terms influences, pressures, and interference, as are so inextricably linked with the independent functioning of any judiciary, are correlative to forces external to the judiciary and the extent to which they may bear on the discharge of judicial functions. These determine the extent to which the judiciary may act impartially, free of bias, prejudice, fear, and other extrajudicial compulsions and constraints. Indeed, the three organs of the state, the legislature, the executive, and the judiciary, in an ideal constitutional structuring, are intended to operate as checks and balances on each other, as governed by an overarching aim of separation of powers. That view entails the necessity for each branch or organ to discharge its functions responsibly and with restraint. Experience shows that such restraint is often elusive, requiring concerted and deliberate efforts at regulating such a separation. Indeed, that objective, as is the bedrock of a constitutional democracy founded on the rule of law, is best exemplified in our jurisdiction by Article 22 of the Constitution, as enjoins upon the state to ensure the separation of the judiciary from the executive organ of the state, while separation from the other organs or branches of government remains the preliminary objective of independent functioning. It definitely is not the sole determinant of judicial strengthening. External institutional separation additionally demands complementary internal initiatives spearheaded by the judiciary itself. This lays the ground for drawing a distinction between institutional independence, constitutionally declared, and judicial autonomy of action in the efficient and transparent delivery of justice. That is, the mutually complementary yet distinctive notions of constituting the judiciary and the functioning of the judiciary. Note that the latter aspect presupposes constitutional latitude at judicial self-governance by internally framed rules and regulations as envisaged, for example, in Article 107 of the Bangladesh Constitution. I take note here of the rarely visited provisions of the Constitution touching upon judicial autonomy and, by extension, judicial independence in Article 107 in general. In a unitary state system in which the propensity is for centralized power, these provisions, as are in a state of disuse, take into account the two-tier or bicameral institutional framework of the Supreme Court and necessitate a distribution of administrative power between the two divisions, that is, the High Court and the appellate divisions, and mandates the exercise of coextensive authority, consequentially permitting of senior judges of either division to determine the constitution of benches in their respective divisions and the assignment of judges to such benches. In my opinion, such institutionalized empowerment of the senior judges of both divisions of the Supreme Court through Article 107 needs to be considered favorably with greater care now. Institutional independence demands that the mode of appointment, regulation of tenure of service, and disciplining of judges be free of executive and legislative interference. This is complemented by universally accepted standards of accountability, which endorse a code of ethics and conduct devised and implemented by the judiciary to gauge accountability. For example, through establishment of a credible, independent judicial ethics review committee, and to enforce disciplinary measures through bodies or tribunals as independent and impartial. Here, the preferred mode of oversight and regulation is one of collegiate authority in the form of a judiciary council with majority representation from the judiciary, while lay representation on such bodies or councils as are assigned independent and deliberative powers of appointments and discipline remains almost universally recommended. The degree of political representation therein is either envisaged to be minimal or indeed emphatically reduced to none at all. The state's constitutional and statutory initiatives at separation must unavoidably vary according as its own constitutional political framework dictates. Indeed, inherent institutional strengths, self-restraint, and earnestness inculcated over time through trial and error at securing independent judicial functioning may arguably deter a politicized appointment and removal procedure to slide irreversibly into the depths of constitutional anarchy. But far overwhelming is the apprehension that insistence with weak institutional frameworks, the notion of separation of powers remains elusive and fraught with risks of upsetting the interinstitutional balance. The argument, therefore, is for elements of independence to be constitutionally, legally, and institutionally formalized to delineate clearly spheres of judicial function free of executive and legislative interference. To this end, the Bangalore Principles of Judicial Conduct provide additional context to the UN Basic Principles on the Independence of the Judiciary in providing primary objectives for the judiciary, two of which are: one, provide a framework to judges and the judiciary for ethical judicial conduct, and two, ensure that judges remain accountable for their conduct to appropriate institutions as are themselves independent and impartial. Indeed, within the Bangladesh Constitution, the elements of the rule of law are readily discernible in the supremacy of the Constitution as the solemn expression of the will of the people declared in Article 7, as well as the separation of the judiciary from the executive endorsed in Article 22. These provisions clearly attest to an independent and autonomously functioning judiciary submitting only to the popular will reflected in the Constitution itself, while sitting in judgment over legislative, executive, and quasi-judicial actions, decisions, and orders. The Republican moorings of the Constitution are therefore undeniable, as is its potential for aiding a better understanding of judicial independence and autonomy under our constitutional dispensation. All that is needed now is the harnessing of political and judicial will to translate that into reality through clearly formulated laws and regulations. Pending such action, we in our jurisdiction would, however, be unduly complacent and myopic in indefinitely nurturing a straitjacketed view of achieving and sustaining judicial independence and autonomy. Jurisdictions around the world today are also readily adapting to altered realities, burgeoning expectations, and self-realizations at serving not only as an organ of state, but as a relevant one. To that end, visionaries continue to guide the strengthening of the judiciary by robustly renegotiating its relationships with the other competing organs and engaging more beneficially with its constitutional and natural constituency, i.e., the general public. The options are many and varied here and range from judges and judicial officers acting as innovators and technopreneurs devising justice delivery products within a system that prides itself on efficiency and cost effectiveness. And the Singaporean experience comes readily to mind here, down to factoring in AI in making sentencing recommendations. Completing a full circle from where I began a while ago, two basic requirements, that is, the respect for the sovereign will of the people and belief in the organic nature of the Constitution, become fundamental for upholding the rule of law. This publication, marking the 50 years of the Bangladesh Constitution, indicates the pathways through which this may be fully achieved, armed with the tools found largely in the Constitution itself. Thank you very much.
Thank you very much, Justice Refaat Ahmed, for, as usual, a most eloquent and erudite presentation. Thank you. And now we will get to hear from the editors of the book. I didn't get a chance to ask whether Ridwan will go first or Rokeya would go first, but maybe just going in order of the names, in the order in which the names appear in the book, let me invite Ridwanul Hoque as the next speaker and to present about the book. Ridwan, please.
Thank you, Professor Kevin Tan, my Kevin, my friend Kevin, no, simply. I would like to begin by giving a big thank you to the Center for Asian Legal Studies at the National University of Singapore for organizing this event to actually celebrate the Constitution of Bangladesh, especially its 50th year. As an editor, I would be speaking actually as an individual person, and this is going to be an academic exercise. So what I'm going to say in just 10 to 12 minutes may not necessarily reflect the view of my co-editor, Rokeya Chowdhury. Mostly my short speech is based on the theme of the book. But nevertheless, I mean, we are probably in an environment back in Bangladesh where I needed to lodge this point of this style. So I have some limited number of slides for the guidance of myself. So I'd like to share the slides now. Please bear with me. I'll take just a few seconds. The book is premised on a basic theme. The purpose is to celebrate the Constitution of Bangladesh's 50th year. So the Constitution was adopted on 16th December 1972. So it reached 50th year of age on 16th December 2022. The individual contributors covered in their chapters the developments only until that year, 2022 December. The theme of the book is we gathered all individual contributors, 14 chapters altogether, to look back what we decided to be our constitutional fate in 1972 at the founding inspirations, founding goals, or founding high ideals, and to reflect over the journey that we have crossed 1972 down to 2022, and to think of the future So where are we heading to? So that's the common theme that every contributor has accommodated within their scholarly activity. So the constitution was written and adopted by the people of Bangladesh through the medium of the Constituent Assembly. And it began with four founding core values: Bengali nationalism, secularism, democracy, and socialism. There is a very sounding mentioning of some of the other constitutional law themes, democratic themes, such as the rule of law, human dignity, and human rights, in the very preamble of the Constitution. And the Constitution has designed also democratic institutions, such as an independent judiciary and an independent election commission, for example. However, as we look back and compare the time that we began and compare the time that we have arrived at, we can see some gaps in the vision and the reality. And mostly the gaps are visible in the sphere of democratic executive accountability. So I would like to see the constitutional journey of Bangladesh through 5 different periods or phases. But you will actually see there's 6. Anyway, I would say 5. The first phase is 1972, 1973, the time for constitutional political building, and democratic formative years. Then 1973 down to 1975, that's an age of democratic decline or constitutional dismemberment or displacement or misplacement. For example, in 1975 January, the Fourth Amendment to the Constitution changed the Constitution, overhauled the Constitution from a democratic constitution to an undemocratic one-party system constitution. Then we have the third period, 1975 down to 1990. That's the period of extra-constitutional military or civil military autocratic regimes. Then the country went back to democracy in 1991, and from 1991 down to 2013 or 2013 is the period of democratic restoration and unstable or malfunctioning democracy. Within this period, the fourth period, we have an exception, and that's 2008 and 2009, during which an emergency government backed by the military, but as a civilian government, and within the framework of the constitution, which used the framework of non-party caretaker government. But the 2008 and 9 emergency government overstayed in powers, breaching the constitutional mandate. Instead of 3 months, that government stayed in power for 2 years. But there is a justification often advanced by scholars, politicians, as well as the other insiders. And the justification was for democracy. I mean, this government was needed for democracy. Then the last period starts from 2013, or more appropriately from 2014 down to present day today. So since 2014, it's one dominant party that's in power, and there isn't actually change of power between major political parties since 2014. So during these periods, or during the constitutional journey of Bangladesh, it is basically the people, the political leaders, political parties, and other institutions, democratic, legal, and fourth estate institutions, that interacted with each other, that interplayed with each other to advance, break, make, or remake the constitution of the nation. And many positive constitutional developments, emerged during the journey. For example, the readoption of parliamentary democracy in 1991 after a long period of autocratic regime or presidential form of government was a notable milestone or step through 12th Amendment to the Constitution, in which all political parties agreed for the first and the last time in the history of the nation. And there is another constitutional innovation, kind of politically agreed, in the sense that it was demanded by the major opposition party of that time, and it was, activated by the party in power. And that's the caretaker government. And under the caretaker government, we had 3 successful elections that happened through 13th Amendment of the Constitution. Then the Constitution also designed some institutions. That's another positive positive development or positive element in the Constitution. One is, for example, parliamentary standing committees. The rule stayed in the Constitution since the very beginning, but it is in 1996 in particular, when the current, the ruling party went into power, that the parliamentary standing committees were activated. Then another important institution on a positive side is judicial activism and judicial vigilantism over executive excesses. However, we have some changes in attitudes and developments that I'll briefly cover. For example, on a positive side, the judiciary made good use of public interest litigation tool to protect the rights of the people, to check the executive excesses, or to act as a kind of constitutional control over the other 2 branches of the state. And another tool that the judiciary used to advance the cause of the Constitution is the basic structure doctrine. Anyone interested in Bangladesh as well as South Asian constitutionalism is aware of the doctrine. So this is a power or the tool at the hands of the judiciary to declare, to invalidate a constitutional amendment as unconstitutional. So the judiciary once adopted and used this tool to invalidate 8th Amendment case in 1989 at the time of a military government. The ultimate result or ultimate positive impact of that exercise was a contribution to the democracy in Bangladesh. So immediately after 2 years of that decision, we saw a change in the political landscape in Bangladesh. The country restored democracy in 1991. I'd like to talk about a couple of genetic defects in the Constitution, or you can say constitutional failures. One genetic defect in the Constitution, in my opinion, is the exclusion of indigenous peoples, the othering of the people who are of indigenous ascent. So this is an example of non-inclusive constitutionalism. It began with the very history of constitution making in 1972, and it continues to exist within our constitutional scheme. Of course, there are some positive developments from the perspective of inclusion, but nevertheless, this is still a big deficit in the constitutional history of Bangladesh. And another defect is the concentration of power in one person, the head of the political party, the ruling party that remains in government. And sometimes it might be president, and now it's the prime minister in the prime ministerial system of government that we have. And here might be there are some gaps between the text and the practices, but it is the practices that dominate for the purposes of concentrating power in one person or in one party. Then Uh, Another defect that also comes from practices is the exclusion of people from constitutional politics, constitutional amendment, and participation. For example, the omission of the non-party caretaker government system by the parliament, induced by or inspired by the judiciary, is an example of excluding the people uh, because when the parliament excluded or omitted the non-party category government system from the constitution, it was actually a parliament that was composed of one party indeed. So there are also institutional abdication. I'm now switching over to constitutional failures to draw a broad picture, not going into much detail. So, for example, we see institutional abdication. So, Parliament has abdicated its duty, and the judiciary has also become quite inactive, visibly inactive, and it seems to be not willing to question the failures or excesses of other two branches of the state. At least in front of us, we do not have any record of decisions to that effect. And there are many reasons, but I see personally, for example, both the text of the Constitution and the constitutional practices are failing to ensure an independent judiciary. The appointment mechanism for the judges of the Supreme Court of Bangladesh is a very flawed one. It's a tiered system appointments, uh, but every single tier appointment is flawed. Uh, on the other hand, the judiciary itself kind of, I mean, underused or hasn't used uh, to the benefit of democracy two of its tools. One is the public interest litigation, and the other is basic structural doctrine. For example, by disapplying basic structure doctrine, the Supreme Court of Bangladesh, in a sharply split decision, 4 versus 3, invalidated the constitutional amendment that introduced the election time non-party category government system. And in my opinion, again, the largest failure seems to be the collapse of the fair, multi-party, and free elections. So the the this claim is supported by many scholarly publications at home and abroad, and international media has also published the reports that show the corruption or the failure of the election system in Bangladesh. So what's in the vault of future for Bangladesh constitution? So one thing we must note, we must give credit to is the endurance of the constitution of Bangladesh. It is the same constitution, despite all the changes and the cuts or amendments, negative amendments to the constitution, is the only one constitution that has been sustaining. So it's a praiseworthy fact to praise. However, this claim actually covers or conceals the failures, some ugly truths. For example, uh, during the whole period of 50 or 52 years, the constitution was amended by parliament or in practice without amending the constitution through the medium of parliament many times to shy away from democracy, to establish autocracy, or to establish constitutional autocracy. So during these periods, the constitutional developments, the goals uh, have showed the divergences. So the politics that we have today has veered away from the high ideals of the founding moment back in 1972. So the country has probably graduated to a nominal democracy today. And the current agenda of the current government, the development agenda, has overridden the constitutional imperatives for democracy, participation, the rule of law, and the dignity of people. And the future of the Constitution is really at the hands of these people, we the people who made the Constitution, and with us at the hands of political parties, political leaders, and the institutions that the Constitution has created. Constitution cannot operate on its own. And as Justice Albisheks from South Africa once said, a constitution is an autobiography of a nation. So if we look at our own constitution, if we look at the history of our own national life, we can see that there is a huge gap between the founding constitutional goals and the current reality. So the actors, all the relevant actors now need to lend their agency to help the constitution be generative of an environment for multi-party politics and multi-party free and fair election system and a functional democracy. Thank you very much for patient hearing.
Thank you very much, Ridwan. You've given us quite a comprehensive overview of the book. Can I now invite your co-editor, Rokeya, to chime in as well? Rokeya, the floor is yours.
My warm regards to the guest of honor, the panelists, my co-editor, and everyone who has joined with us today. I would also like to take this opportunity to thank the Center for Asian Legal Studies at the National University of Singapore. My co-editor, Dr. Ridwanul Hoque, who has also been my teacher, mentor, and my supervisor for my research work in the past, has wonderfully summarized the editorial chapter and given a foreground to the work we have been doing. So I do not have much work left to do here. I will share some ideas in broad stroke. So in the grand scheme of things, 50 years may not be too long. However, in the constitutional journey of a legal system, 50 years is a significant milestone. In 50 years, there have been inroads and trajectories in the constitutional discourse of Bangladesh, which demand scrutiny and attention. At this juncture, it is important to ask questions and look for answers from as many perspectives as possible, which can then lead us to new beginnings. And this has been the major pursuit behind this editorial collection. In this editorial collection, we have established an early career legal and constitutional scholars and legal professionals addressing various facets of constitutional issues. Personally, this has been an opportunity for me to rethink, relearn, and unlearn some of my own thoughts and inhibitions on constitutional research. On that note, I'm going to pose some questions and not necessarily answer them. How reflective is the constitution or constitutional practice in Bangladesh of the collective hopes and aspirations of its constituents? How inclusive is we the people, the musical opening of the preamble to our constitution? Does the constitution give equal voice and deliberative decision-making to all the different identities, gender, class, language, religion, ethnicity? Nationalism is a founding principle of our constitution. Despite its many promises, Bengali nationalism has proven to be hegemonic. Our constitution does not recognize the indigenous peoples of the country. It uses the words explicitly, and I'm going to quote, tribes, minor races, ethnic sects, and communities, unquote. These are not the words that reflect the lived realities of the indigenous peoples in Bangladesh. And this is, in fact, a barrier to the recognition and realization of their rights. Coming to secularism, also a founding principle, which has become ornamental as the Constitution endorses Islam as state religion. It also says that other religions have the same status and people coming from different religions have the equal rights. From this, some have argued that recognizing Islam as the state religion is a mere tokenism for the majority Muslim population. But it remains questionable that the state is an abstract entity, and why does state need religion? When a constitution has state religion, what are the implications for the legal system. Similarly, if we take a step back and ask if the Constitution endorses the word secularism, what are the constitutional implications and what are the implications for the legal system? I believe that those questions have never been adequately answered. We have many constitutional amendments and we have many court decisions, but the question of identity has always conveniently been sidestepped for the court to decide, who often, like where we often get the decision that it is either a political question that the court is not comfortable to answer, or it is left to the aspiration of the people. But is there a way where we have really tried to quantify what are the aspirations of the people? And that is where we come to the politics of language again. Similarly, when it comes to affirmative action, the Constitution uses the words backward section of citizens, as though these citizens themselves are responsible for their backwardness, whatever that might mean. And the state has no responsibility. It is absolved from all responsibility, and there is no political, historical, and social context to this backwardness. A constitution is not any document. Each word in the Constitution must be carefully crafted, and they must also evolve with time. There must be mechanisms within the Constitution and the broader legal framework to deal with change and to be accommodative of diversity. Instead, we now have an eternity clause in our Constitution, which basically says that the fundamental principles of the Constitution cannot be altered even through further amendments. This literally translates that we are limiting the power of the future generation to amend the Constitution and to leave it to the fullest of its possibility. And this is where we come to the question, in 50 years, have we seen fruition to constitutionalism? Is there deliberative and representative democracy? Is there rule of law, independence of judiciary, and separation of powers? Is the constitutional system capable of upholding justice within the national bounds? Is the constitutional system, the representatives, keeping their promise to international commitments? These are all important questions. But for any democracy or perceived democracy, perhaps the most important question that needs to be answered is, are people or citizens able to ask these questions freely and without fear? I am going to end with this question, that in today's Bangladesh, are we able to ask questions freely and without fear? And since I'm a big fan of poetry, I'm going to quote Tagore, and that is my hopes and aspirations and wishes for Bangladesh's constitutional journey, where the mind is without fear and the head is held high, into that heaven of freedom, my father, that my country awake. Thank you.
Thank you so much, Rokeya. What a poetic, and I think you've asked enough questions for everybody afterwards, and I'm not sure how many of them Ridwan or you yourself might be able to answer. But before that, we get to hear from the commentator. Now, initially, we were supposed to have two commentators on this panel, but unfortunately, Professor Ali Riaz has been indisposed and is unable to join us. So Cynthia, Farid will have to carry the burden of being the sole commentator for this book. So Cynthia, the floor is yours.
It's not at all a burden, although I was looking forward to seeing Professor Riaz and also hearing what he had to say. So a very good morning to everyone. And I want to thank you, the organizers at the Center for Asian Law at NUS, for this invitation. I have read the book and I have listened to all of our speakers today with a great deal of interest. The book is a celebration and a critical examination of the Bangladesh Constitution on its 50th anniversary. And it really provides the reader with a host of different perspectives on gauging the extent to which Bangladesh has become the country that the founders of the Constitution had aspired to build. So the book is divided into 4 parts that variously look at aspects of founding and identity making, institutional aspects of constitutionalism, judicial review and rule of law, political parties, parliament, and lastly, social justice and rights. And I will not encapsulate all the individual chapters here. So my commentary really broadly relates to sort of three things. The first of which is where does this book sort of contribute within the field? And I think that with regards to this first point, South Asian constitutionalism have in the past been referred to as unstable, and the instability may be better understood if we take a long view of the development of constitutionalism, which of course began with shared British-Indian roots, but significantly diverges after the post-colonial break. And within this context, the Bangladesh case is perhaps unique in that the break comes after the first wave of decolonization, when borders had been largely settled. And I think that each of the chapters are major contributions in their own right to the field of Bangladesh constitutional studies, comparative constitutional law, and South Asian legal studies in general. And if the audience might indulge me on a personal anecdote, when I started graduate studies a little over a decade ago, there was a distinct dearth of Bangladeshi scholarship in international journals and publications. And in this context, Professor Ridwanul Hoque's contributions were foundational to many of us sort of getting into the sort of scholarship and academic work on public law. And I'm also really glad to see the other authors, including Professor Riaz, who have been instrumental for expanding Bangladesh studies through their consistent contribution and collaboration with peers and younger scholars. Which then brings me to my second comment, which is on the fault lines and critique of the Constitution. The chapters across the book identify certain fault lines within the Constitution that have generated highly contested debates and a variety of critique. And many of this has been covered by the authors. They've alluded to various different types of critique in individual chapters. And I think that some of these fault lines operate at two levels. First, at a broad level, it might be understood, these fault lines might be understood if we evaluate the four pillars of the Constitution. That is democracy, nationalism, socialism, and secularism, which among other parts of the Constitution is enumerated in the preamble. The founding aspirations behind these principles were that democracy would usher in socialism, which would ensure a free and egalitarian society. Nationalism and secularism, in addition, complemented that egalitarian project by ensuring that individuals were foremost bonded by their national identity and that religion was practiced freely and or kept out of the sphere of politics. Now, the last two, of course, are largely informed by experience before and after the partition of British India. Now, some of these principles are also interconnected. The trajectory of nationalism and secularism illustrates how these came to be fodder for mainstream and electoral politics. Nationalism has not only been contested, but the Bangladeshi citizenry has on occasions been confronted by the question whether Bengali or Bangladeshi nationalism is itself secular. And these are unresolved, largely unsettled questions, and these may well evolve into a set of entirely different debates going forward. Now, this then brings me to the principle of socialism, which is briefly considered in one of the chapters, which correctly pointed to its rather rhetorical status as a means to achieve an egalitarian society. The discourse on socialism is heavily skewered. The constitutional text itself refers to, and I put this in quotes, toiling masses and backward sections. And the political discourse of leftist or communist parties have generally reduced political claims for socialism to the right to food, clothing, and shelter before all other rights. And this is a South Asia-wide phenomenon and not just Bangladesh. The liberal constitutional promise of emancipating the poor has been foundationally elite-driven and also elitist. This is, again, is an issue not just for Bangladesh, but also the wider region where liberal constitutions prevail and where socialist promises have been made and remain unfulfilled. This brings me to the fourth principle of democracy, which is promised as the means to achieve socialism. Democracy has been and continues to be an arduous terrain. And it's here on this principle that we find the biggest fault lines of the Constitution, which then brings me to the second operative level of fault lines, right? So one being the more abstract meta level, and the second being at the institutional level. So the book evaluates the different institutions that are central to upholding constitutional law and the rule of law. Many of the chapters pointed out to the highly centralized nature of political power and its concentration in the executive office. We have to understand executive heavy-handedness in both its historical and contemporary context. The Constitution, despite emancipatory promises, was imposed on structures and logics of governance with path-dependent features because of the colonial experience. After independence, development of these institutions, the parliament, for instance, was disrupted either by direct authoritarian encroachment in politics or political parties chipping away at institutional autonomy. The net result of all of this has been the creation of a very tall order for the judicial branch and the Supreme Court. Justice Ahmed's eloquent account of judicial decision-making, and among other things, the intertwined nature of law and morality upon which justice is based, gives us a glimpse into the role of the Supreme Court and the judicial branch, which, as outlined in that chapter, shows that the judiciary has a distinct role to play in formulating precepts of justice, which in turn fortifies and renews the social contract, or the Constitution's evolving status as a social contract. If we consider the social contract, it's for every citizen. It's for women and minorities. So the gender contract, or the gendered and other aspects of the social contract, are yet to substantially evolve. And the question then is, can we only depend on the judiciary or the Supreme Court to fulfill this social contract? In the Bangladesh context, and I think this is also a trend prevalent within South Asia, is that the court has had to play the role of a court of equity and justice, something it has been trying to do since the 19th century in this region with equity, justice, and good conscience. The Supreme Court has also played, in addition, a role in governance and policymaking. And previously, in the Bangladesh context, it has played the role of ensuring integrity of elections. So where then does the responsibility lie for fulfilling the social contract? I do not think that we should put all of the responsibility of getting everything right the first time on the shoulders of the founders. This is an originalist position. In some ways, it's rooted in the American constitutional experience. In the post-colonial context and in a post-conflict context, faced with political and other contingencies, the founders of the Bangladesh Constitution had to redraw South Asia's map and reimagine a country which just 50 years ago was considered a basket case, and 50 years later presents a promising development miracle. So coming back to the social contract, the responsibility of this contract resides also with the other political institutions and political parties in particular, as much as the Supreme Court. It was refreshing, really, to see the substantive focus on the functions, or rather the dysfunctions of Parliament. If we consider the fundamental principles of state policies alone, which are similar to the directive principles in the Indian Constitution for those that are not familiar with the Bangladesh context, and these fundamental state policies are stated to be non-justiciable, but on this score, the Parliament has spectacularly failed in its functions. And this is despite the option that it has to enact laws to realize the state policies by leaning on Article 47, which would, of course, raise additional questions about abridging fundamental rights to give effect to these policies. But this has not even been a conversation within the political discourse. And all responsibility of setting the social contract right seems to still reside with the judicial branch, which, by the way, has been struggling with its own institutional autonomy. The book does a brilliant job of offering different and critical perspectives on this evolving social contract, and perhaps signals a shift to examining constitutionalism with reference to these other branches. This then brings me to my third and final comment, which is on future directions of constitutional studies in general. The editors had stated their mission at the beginning of the book in the introduction, and the mission was to look back, evaluate the present, and forge the way forward. I think that they have succeeded in that mission. The chapters consider a wide range of perspectives on the Constitution. And the fact that this book has actually brought together not just full-time academics, but other legal professionals and practitioner perspectives illustrates pioneering and incredibly substantive ways of bringing together a superb group of scholars. And I really want to highlight often how incredibly difficult this process is, especially edited volumes, and it really speaks to the respect that the editors inspire. In addition, having a look at this forum today, this book talk at NUS, it speaks to expanding conversations within and between Asia. So between Southeast and South Asia being beyond India. And these things do not happen in the abstract, and centers don't run in the abstract. So over the years, I've gotten to know several NUS faculty affiliated with the center, including Professor Andrew Harding, Professor Kevin Tan, and Professor Jacqueline Neo, and their breadth of work and collaboration, particularly within Asia, speaks to scholarly generosity and commitment to expanding the field. So coming back to this book, it's certainly going to be foundational to further scholarship within the field, not just Bangladesh, but also beyond. It will also expand theorization and debate on constitutional law and legal studies on also beyond South Asia, so Asian and Global South constitutionalism, which are both currently expanding subfields within the comparative constitutional law field broadly. And the book has also perhaps set the stage for engaging with the Constitution through interdisciplinary and critical perspectives, including perhaps on the legal profession in the future, which is vastly understudied. On all these counts, therefore, and for its pioneering efforts, I congratulate the editors and the author. Thank you so much.
Thank you very much, Cynthia, for your critique and some suggestions, and as well as for the nice plug of the Center for Asian Legal Studies and the work that we try to do here. So we now come to the most exciting part, I suppose, of the presentation and of this particular panel, and that is the question and answer and response from the editors of the book, as well as from everyone else on the panel. So we've got a list of some questions here already on the Q&A. And as a reminder, for all of you online, if you would like to pose questions to anyone or to the panel at large, please use the Q&A function. And I will do my best to try and curate them and then sort of field these questions in turn, right? So I suppose let me ask, just direct this question probably to Ridwan as the lead editor, simply because this is the one where this question comes from Upasana Dasgupta of OP Jindal Global University. And the question is about the impact, whether or not in the period around 1919 and 1935, whether the government of India acts at the time that were being enacted, did they have any impact on the Bangladesh's constitutional journey? And were there any lessons learned from the period leading up to 1947 from sort of the Indian experience?
Thank you, Upasana. This is a fantastic question and difficult question, I must admit. No constitution is born out of nothing. So the constitution that we have actually is impacted by or influenced by its former constitutions. For example, the constitution of Pakistan and the pre-1947 constitutional regime that existed during the British era. And yes, it has these two legislation in particular, the Indian Independence Act 1919 and 1935. The later was the Constitution of Pakistan until 1956. So had impact and influence, of course, but whether we have learned lessons from them, with regard to that question, the framers of the Bangladesh constitution deliberately wanted to avoid the defects of these constitutional instruments from pre-1947. For example, the Bangladesh constitution's the liberty provision, the personal liberty provision was very strong and quite strong. And the judiciary was given power to act on the question of deprivation of liberty. So the writ of habeas corpus, and in a model that that wasn't seen in the UK system. But immediately after that, we changed the liberty provision, and we introduced the same emergency preventive detention that we experienced before 1947 as well as during the Pakistan period. So I can't say that, I mean, so we have learned lessons, but there were some trials, some tries. One positive aspect from the pre-1947 constitutional atmosphere, whatever it was, is the constitution, the formation of parliament. Say, for example, the seats for women, reserved seats for women, that has a history going back to pre-1947 time. So that continued during Pakistan period, and we borrowed that one from Pakistan. But nevertheless, we have later abused that system. For example, we have increased the number to sort of number of the reserved seats for women to increase the power of the political party that's in power of the ruling party. Thank you very much.
Thank you, Ridwan. The next question, I think I will direct this to Rokeya, because you did in fact talk a little bit about the problem of inclusiveness or non-inclusiveness and minorities. So this question comes from Mohammad Mamunur Rashid. Does the Bangladeshi constitution contain any particular term, any particular minority as a national minority to offer proper protection to them? In other words, is anybody being singled out for sort of special treatment?
Thank you for the question, and I would say thankfully not. I personally find the construct of majority and minority a bit problematic, and to word a constitution in that manner, it would encapsulate, I would say, constitutional complexities, and we do not have like designated national minorities, but the reference to minorities in the constitution in terms of gender and identity, as I have identified a bit while I was talking, in terms of gender and also linguistic identity, is a bit problematic in how it is worded, and it would be fair to say that it is not reflective of the international aspirations or to the treaties that we have accorded to or acceded to. So no, there is not, to answer simply.
Well, maybe I can chime in and sort of supplement that question a little bit, right? In other words, okay, if you say that things are not quite in a satisfactory state, then what are the controversies? In other words, were there groups of peoples within Bangladesh that have actually come to court or have actually protested about being somehow discriminated against, right? Within within the polity.
So it started right at the beginning, as Professor Hoque had identified, right at the beginning of the constitutional journey, and it happened at the Constitutional Assembly when the representatives of the Chakma community particularly identified themselves as a distinct linguistic identity from Bengalis. And this particular question was asked because the Constitution said the the linguistic identity, the people of Bangladesh would be known as Bengali. And it is a legitimate question to ask if someone does not, if their language is not Bangla and they do not identify as Bengali or Bangali, why would they want to have that identity? And that is the question that still persists today, that the citizens of Bangladesh, the constitution said, would be known as Bangladeshi, but the national identity is of Bangali, which goes to the language, only one linguistic identity, but no other ethnic identities are recognized. And there is firstly that question. Then as we this has been litigated in the court too in many ways in terms of to be very brief, in terms of the legal framework as well. There is a concentration of indigenous population in the Chittagong Hill Tracts region in Bangladesh, 13 indigenous peoples to be particular, and there are at least, or has been at least 43 different linguistic communities in Bangladesh whose rights are not protected. So that is one aspect. Then we can question from a gender perspective, because the constitution says, and I do not have the exact code, but how it is encapsulated in the constitution, it's almost says that women would have the same set of rights as men. So as if being a man is the ideal, and as woman you get the derivative or subset of rights. So which does not, I'm going to wear my gendered hat now, and that makes me angry when I read the constitution. It also is not reflective of, as Dr. Farid has identified when it says the toiling masses and that sort of elitist perspective. It's not, it uses the terms as backward sections. There's the question of religious identity, that it almost in terms of when we look at the secularism provision that is there now, or the state religion provision, it says Islam is the state religion. However, other religions will have the same status. And if you look at how the religions are named, it's actually by the concentration of the population. So it's almost like a number game. So there are those identity constructs that are very much problematic within the constitution. Then we do not live in a world where we can go by the gender binary. So the constitution does not also reflect on that. There are many evolving aspects which are not covered, and there might be question of economic aspects and all that. So that all needs, I think it is a good time to get back to all that and clear that mess.
Thank you. Well, in danger of like putting you on the spot again, I just thought maybe a little bit of clarification. So you mentioned this whole thing about Bengali, the language, as opposed to Bangladesh, the people, and so on. Are there any formal policies in regard to that? For example, do state schools insist that you have to study Bengali, you have to pass Bengali exams in order for you to get into university and things like that? I mean, that obviously has a direct impact from a practical point of view in relation to minorities, right?
That is a very significant question. But just before I go to that question, I want to clarify something, because Bengali versus Bangladeshi is also a big debate in Bangladesh. So there was one state where the word Bengali was even, it became controversial, and it was replaced with Bangladeshi, because there is this whole identity question of being a Muslim versus being a Bengali. There's a whole social construct to this, and that is another constitutional debate. Just wanted to clarify on that. And then coming to the question you asked, it is not mandatory. We have many streams of education, and it is not mandatory in all streams to learn in Bangla. But for if we are going to look at the question whether the state offers primary education in all 43, or let's say 23, or whatever number of languages there should be, it is not there. People are not able to access, not everyone has the ability to access education, primary education, at least in their mother tongue.
Thank you. The next question comes from, well, it's from an anonymous attendee, but nonetheless a very interesting question, because all of you have alluded to this whole question about the social compact, what it consists of, and so on, and sort of the four pillars of sort of the Bangladeshi identity or the constitutional identity. So this question has to do with the definition of secularism, right? Does Bangladesh define secularism within this political and social context? What role does the state religion play? Islam in this case, in the governance and legal framework of Bangladesh. I'm not going to direct this to anyone. If anyone on the panel would like to take this question, I would much appreciate it.
Probably I'll just trigger the point, and
Yes.
Rokeya or Cynthia, Farid, or Justice Ahmed, if he likes, can sort of supplement. This is $1 million question. So what's the constitutional or national identity of Bangladesh? Do we have one single identity? Are we a democratic constitution? Are we a secular constitution? Or are we Bengali as a nation? So all the four identity markers, so democracy, secularism, nationalism, and socialism, have been hugely contested right from 1973 down to 2024. And today we have secularism along with state religion, Islam. Today we have Bengali nationalism along with the identity of citizens, individual citizens, as Bangladeshis. And today, I mean, democracy, we have democracy, but we have variations of democracy as well. And socialism, so it's a big question whether socialism is being practiced. But with reference to the definition of secularism within the constitutional scheme, yes, we started by defining secularism. Then the secularism principle was taken away from Constitution from 1975 down to 2015. So in 2015, the Parliament enacted the secularism provision back to Constitution. And this time, a new thing happened. The Parliament, at the same time, amended the Religious Equality Clause. And for the first time, so the Constitution was naming Hindu, Buddhist, Christian religions will also be equally practiced without interruption. So earlier we began with a non-interference with other religions or equal right to practice other religions as well. So yes, we did define secularism, but in practice, I mean, whether that definition has been practiced in the constitutional governance is a big question. And for state religion Islam with or state principle secularism, to what extent it has got impact on the legal system? That's also a question. For example, we have some specific religion-specific laws, for example, madrasas, masjids, and other religious property management kind of thing. And we have some welfare foundation laws for Buddhists and Christians and other faith group people. So it's a difficult question to navigate through, actually. Thank you very much.
Thank you, Ridwan.
If I may add to the...
Yes, Judge. Yes, please.
I'm taking a cue from the brilliant deliberations by Cynthia, Farid, Rokeya, Chowdhury, and Dr. Hoque. The question of Bengali and Bengali nationalism. I think the question that many of us are asking nowadays is, has the nationalist agenda in this country outpaced and overrun the other exigencies of state and institution building the past half a century? And the issue here is that Bangladesh is a relatively new state that has accommodated an old nation. And if you trace the roots of Bengali nationalism, roughly, I would sort of put a time limit to the first partition of Bengal in 1905 that was annulled several years later. And if that is so, is this attributable, the higher ranking of the pillars of state formation and that place being occupied by nationalism, is that attributable to the genesis of Bengali nationalism, i.e. Bengali Muslim majoritarianism, being of far older provenance than state formation? And I think many of us are beginning to realize that it is the case the whole debate about secularism, and in fact, we in our state formation and institution building veering towards Bengali majoritarianism gives us an idea as to why the dominant nationalist narrative of the Bengali majoritarian ilk has far outpaced reliance on the other pillars for state and institution building in this country. And my conclusion here is that between nationalism, socialism, democracy, and secularism, an overemphasis and reinforcement on nationalism in preference to the rest has given rise to the specter of a unique brand of nationalism which has gained currency of late. And the other ideals, unsurprisingly, have remained elusive, and democracy has taken a definite battering in particular. Thank you.
Thank you. Thank you very much, Justice Ahmed. Since we've got you in on this intervention, there seems to be a good question coming in from Imran Siddiq that might be best answered by you if it's not too sensitive. So the question here is that with regard to the appointment and removal of Supreme Court judges, theoretically, appointments and removal are supposedly judicially driven, but the executive undeniably plays a large role in such exercises, and in some cases impinging on judicial independence. So to what extent, if at all, should the executive play a role in the appointment and removal of judges of the superior courts?
I think I touched on this in my opening remarks, and this has to do both with the interface of the concepts of judicial independence and judicial autonomy. And I think the impetus has to come from within the judiciary itself. We are at a crossroads now in terms of appointments, elevations, disciplining judges, and there is a void that needs to be addressed through judicially initiated efforts at formation of independent committees and councils with majority judicial representation, lay representation if possible, but without, ideally, any political representation. So wresting the control, as it were, from the other organs by the judiciary and bringing it within the folds of the judiciary. As I said, we are at a crossroads here at this point in time. Thank you.
Thank you. Thank you very much, Judge. Now there's a number of questions talking about sort of future trajectories. One question from Subidin Ibrahim asks about the question about the 14th Amendment. What's the road ahead with that? And maybe the sort of the future weaknesses and fault lines. I think some of that has been touched on already, so no need to answer all of this. But also a question from Anna Di Stasio on what lessons may be drawn from the Bangladeshi experience going forward, and that may be used for other countries, other developing countries in the development of their constitutions. And from Jahidul Islam from Southern University in Bangladesh, the question is, what the impact, what might have a commendable impact in the future of the Constitution. So I'm kind of lumping these sort of in the future type questions together. And so, maybe to throw it out there and see if any one of you would like to pick up any particular strands of this. Ridwan.
So, Kevin, I just make some brief comments because the three questions seem to be quite similar in terms of the answers that need. But before that, if you permit me, Professor Andrew Harding posed a question to me, and I answered briefly. That's why the question disappeared from the
I was wondering
line.
where Andrew's question disappeared to. Okay.
Yeah, so So that's my fault. Actually, I just quickly replied. So would you allow me to just
Yes, please.
take the question first? And
Yeah.
Okay, so Professor Andrew was saying regarding what you call the development agenda, the overriding, the, that's overriding rule of law, human rights, and democracy in the name of development. That's not unfamiliar. However, it would be interesting to know how development is being defined. If it simply means economic bottom lines, then that definition is quite inconsistent with the Millennium Development Goals, etc. Should it not be argued that development is precisely about the rule of law, human rights, and democracy? And without those and recognition of a broad definition of development, the pursuit of development will always be futile for the benefit of the for the for the benefit or benefiting the few, not the many. Professor Andrew Harding was my mentor. He was my co-supervisor, my guru at SOAS University of London. But he soon left SOAS immediately after I joined as a PhD scholar. Anyway, so Andrew has given a clue for my answer. Yes, I personally would like to define development as aligned with the rule of law, human rights, human dignity. And in the Constitution, we have a mandate in the preamble, though, and in the chapter that deals with fundamental state policy principles, that the state will take development equally, so that the benefit goes down to rural areas as well. So benefits are spread across the nation. So that's the constitutional mandate. And also there is a mandate that the measures should be taken so that no unearned income or unaccounted property can be gathered by people. So that was referencing to corruption. So in today's Bangladesh, development is defined as basically infrastructural developments, bridges, culverts, and the roads, highways, metro train, all sort of things. So there isn't any assessment of the developmental needs of the people. Keeping in terms with the rule of law, human rights, and democracy. So it's a quite reverse developmental agenda in Bangladesh. That's my opinion. And with reference to other questions, yes, for constitutional cross-learning and borrowing, yes, we can probably import a few lessons to other new nations or the nations who are remaking or newly amending, newly writing their constitutions. So the Bangladesh constitutional making experience is unique in the sense that it developed the constitution within a shorter period of time. It collected all public opinions, but it didn't refer to the people for a referendum. But the legal argument developed or justified or advanced was very interesting. So the Constituent Assembly was formed with the public representatives who were elected in the 1970 election. And that election was actually called for the making of a constitution for Pakistan, United Pakistan. So there are the legal arguments. And one more thing that we can export is probably the careful interaction with the past constitutions. The Bangladesh constitution interacted with its past constitution, Pakistan's constitutions very carefully, so that the bad things are not, spilled into the Bangladesh new journey. For example, we are talking about the minority protection. In Pakistan's constitution, there are clear references to the word minority and minority protection. So the framers of the Bangladesh constitution didn't borrow that style, rather relied on the principles of equality and non-discrimination. So these are the few things probably the other nations can look at. And what about the future of Bangladesh? So
Dot-
yes, our activism also is a big factor in shaping the direction of the constitution in the future time. Thank you.
Thank you. Thank you. I'm so sorry. This has been a fantastic discussion. And the obviously interest in the Bangladesh constitution and the lessons that we can learn therefrom will certainly increase with more people reading this book. I, for one, have been much enriched by the lessons that I've gleaned from there. I obviously have my own biases. I was wishing, for example, maybe one chapter on sort of state-military relationships and the constitution, which would have, I think, made the story more perfect. But there's more for others to come in. So with that, I want to thank, first of all, our guest of honor, Justice Syed Refaat Ahmed, my good friend Ridwanul Hoque, Rokeya, Dr. Rokeya Chowdhury, editors of this wonderful volume, and of course, Cynthia, Dr. Cynthia Farid, for joining us in this wonderful session. And to all of you who have joined us, good afternoon, good evening, good morning. Have a good day. Thank you very much. Goodbye.